This is Steve Morris with this overview of intellectual property. First, a quick disclaimer. This is, of course, not legal advice. This is educational material. You really should talk to an attorney to protect your intellectual property. Now, first, a definition. What is it that we mean by intellectual property? Well, it's a pretty broad thing. Creations of the mind for which exclusive rights are recognized. We'll get back to the rights in a minute. Could be musical, literary, and artistic works. It could be discoveries, inventions. It could be words, even including computer code, phrases, symbols, and designs. But again, things that have exclusive rights. What are those? Well, those would be things like copyright rights or trademarks, trade dress, utility patents, and design patents, and trade secrets. We're going to run through these one by one to talk about what kinds of protection they might afford. Beginning with copyright. What sort of rights are we talking about if you have a copyright? Well, it's an exclusive right for the holder. Five types of rights in particular: the right to reproduce the work, to prepare derivative works based on it, to distribute copies of it and to perform it, if appropriate, and the right to display the material publicly. That's a lot of rights that the owner of the copyright has unless they assign it to somebody else. The author of a copyright is the creator of the original expression, and the author is the owner of that copyright unless it's a work for hire, in which case the employer or the commissioning party is the author. Now, work for hire is a work prepared by an employee when it's just within the standard scope of his or her job, or if it's specially ordered and or commissioned in a specific circumstance. Now, copyrights are automatically granted in the US. If you create an expression of something, a picture, a drawing, words, whatever, then automatically you have a copyright in it. Again, unless it's a work for hire, but the copyright right is created automatically. But adding the little circle C symbol to the copyright has benefits. You don't have to do it. It's automatically copyrighted. But if you do that, then somebody violates your copyright and uses your material. You can get higher damages when you sue. And of course, there's less chance that they can claim, it was an innocent infringement. Well, not with a circle C there. It's pretty obvious they knew it was copyrighted. You can also register a copyright. You don't have to, but you can. If you do register it, you can seek additional statutory damages and ask for attorney fees. So there are some advantages, and those are good things to talk to an attorney about. How long does it last? Well, the life of the author plus 70 years, or in the case of a corporation, 120 years after creation or 95 years after it is actually published. So they last quite a while, but not forever. Now, what kinds of things can you copyright? Well, things like website content, both the graphics and the actual text, blog posts, computer code, sales material, etc., but not ideas, right? It's the actual expression of a thing, like the actual words, the actual drawing. Ideas can't be copyrighted. We'll come back to that idea when we talk about patents. Now, a couple thoughts about copyrights and the startup. A founder owns what that founder creates in terms of owning the copyright on it, unless there is an agreement in place that assigns that to the company. So that's a very good thing to do very early in a startup. Like as soon as you bring a team on board, have everyone sign that contract assigning their IP to the company. Talk to a lawyer about that. Very important step. Another thing to think about, did you sign an IP assignment agreement at your previous job where you assigned your intellectual property to that company? Well, that's a good thing to go back and read. If you came up with your idea for your current company at your previous company, could be that your previous company actually owns that idea. Go read your agreement and talk to an attorney. And by the way, same question goes for any other founders. You want to make sure they're not assuming they own ideas that they don't own. And in general, you want to be careful you don't use intellectual property that you don't own. So be sure that all of your founders, employees, contractors, etc., aren't bringing intellectual property into your company from, say, previous companies when they don't own that IP. Very, very good thing to be careful about. You will, for example, not be something investors want to touch if you can't prove that you really do own your intellectual property. So talk to an attorney to make sure that your IP is clearly your own. Now, on to trademarks. Very different type of protection. A trademark can protect a word, a phrase, a symbol, or a design, or a combination of those. And the whole focus is on identifying or distinguishing the source of goods. The idea here is to eliminate confusion in the market between one party and another, so customers don't get confused about whose company this represents. And these, of course, would be symbols like the ones you see all the time, as you can see across the bottom of the slide here. Now, trademarks can be established either through use. You can simply use the TM signal because you're claiming this particular word or symbol or whatever as a trademark, or you can register them. And if the registration is accepted, then you can start to use the little registered trademark symbol. You're not supposed to use that until and unless it actually gets registered and approved. You must actively use and defend your trademark to maintain it, whether or not it's registered. You always have to use it and defend it. Now, theoretically, it can be maintained forever. Once it's registered, you have to do this affidavit of use between the 5th and 6th year anniversary, and you actually have to renew the trademark every 10 years. So there is a little bit of maintenance required. There are some advantages of registering the trademark instead of just using the little TM signal. And you can see the advantages listed here. Things like a legal presumption that, yes, you have the trademark. You can have the right to use the little circle R symbol, and you can gain incontestable status after 5 years, which makes it even harder for somebody to try to take your trademark away. How much does it cost? Well, to apply for a trademark, $225 per class of goods or services. Now, you can apply to get a trademark protection across multiple classes, and there are a lot of them. It's a really good thing to talk to an attorney about which classes you should be a part of. Then, of course, if somebody complains about your application, your trademark being too close to theirs, it may take additional attorney time. And yes, you want an attorney for this because you want someone who understands how this process works and can work with the government representative to try to make sure that your trademark is actually awarded. Now, a couple of thoughts about trademarks and the startup. You might want to think about your company name, your product name, your logo. Those are things you might want to at least consider trademarking. Again, talk to your IP attorney to figure out what makes sense for your company. Also, keep in mind, for these kinds of things, IP assignments apply here too. Whoever designed your logo, if it was, say, an artistic founder or some design company, they own that logo unless they assign the rights of that logo to the company. So that, again, is another good thing to talk to your attorney about. Trade dress is another type of protection. In this case, it's protecting against the packaging, the look of the packaging or the appearance of the product itself, and having others imitate that. And to have trade dress protection, you have to have some kind of distinctiveness. Now, it can be a distinctiveness that's obtained through what's called secondary meaning. For example, in my mind, the classic example is the original Coke bottle, which had the sort of very artistic spiral sort of design to it. It was very different. Over time, it became very much associated with Coca-Cola, and that was the secondary meaning. Through use, that distinct product design came associated with Coca-Cola, and that allowed them to seek protection through trade dress. Now, you don't have to register trade dress, but like a trademark, it can be registered, and it does have advantages, including this idea that it can become incontestable after 5 years. Some examples of trade dress, things like, again, the shape of the Coca-Cola bottle, or the front grille of a Rolls-Royce, the shape of a classic Ferrari, or that round wall thermostat design from Honeywell. Good examples. Okay, on to the world of patents, where we finally get into protection of ideas and inventions. Now, a utility patent, for a start, is a property right. It's granted by the government. We'll start here with the US. Obviously, each country has their own. It gives the right to the inventor to basically stop others from making, using, selling the invention throughout the US or importing it into the United States. That's a pretty strong ability to exclude others, but it only lasts for a limited time. It's not for forever, and it's in exchange for you disclosing exactly how the invention works. And this, of course, is something that can protect actually an invention or an idea. A copyright doesn't really protect an idea. It protects an expression, right? Like specific computer code or a specific poem or a specific drawing, but not really an idea. Patents protect an invention or literally an idea. Now, of course, each country is a little bit different. So another good thing to talk to a patent attorney about. Now, a patent requires that what you've come up with is novel and non-obvious. It, again, doesn't last forever. It lasts for 20 years. Now, you can do a provisional application. It's not a provisional patent. It's not really a patent at all. It's simply a provisional application that reserves your date for a year. It gives you a year to fill out the complete application. But remember, the provisional application is only as good as the scope of the description. So even a provisional application takes some serious thought and time and effort, because you need to make sure that your description in the application covers everything that you're going to be claiming later in your actual claims. How much does the patent cost? Well, it varies greatly. It's a good idea to start with a patent search, and it's a good idea to have somebody do that knows what they're doing, to just make sure that what you're patenting isn't already out there in the art today. And, that may be $1,000 to $4,000 kind of typical range. Preparing the actual patent, I've seen them as inexpensive as $5,000, but they certainly can be $15,000 or more, just depending on how complex it is. But then there's the question of prosecution, of sort of negotiating with a patent person at the Patent and Trademark Office to get it accepted. They may push back. There may be a lot of negotiation. And you really do want an attorney doing this that knows what they're doing, that knows how the process works. That obviously involves some attorney time. That'll cost more. And then the big cost can be down the road. If somebody violates your patent, that can be very expensive. If some big, deep-pocketed company violates your patent, it can potentially get into millions of dollars, which, of course, for a startup can be very difficult. And strategy there is, of course, something you'll want to talk to your patent attorney about. Now, who gets a patent if two people invent something at roughly the same time? Well, it's the first to file. Used to be first to invent, but no more. The patent goes to the person who gets it applied, the application in first, regardless of who actually invented it first. And invent here means who actually came up with the idea and then who reduced it to actual practice. Now, there's a different kind of a patent, the design patent. And that is granted on the ornamental design of some functional item. Now, examples might be designs in jewelry or furniture, beverage containers, computer icons. The purpose is not to avoid confusion, unlike a trademark. It's rather to protect this design as a design of a functional item. So that's a little different than avoiding confusion in the market. And of course, again, each country in the world has its own different approach to design patents. Finally, trade secrets. Now, trade secrets are a way to protect really any valuable commercial information that gives you some business advantage. It can protect inventions and ideas or compilations of data. And you have to take reasonable steps to safeguard that information. Things like having people sign non-disclosures before you reveal anything about your trade secret, take security measures, lock things up, and so forth. Now, the nice thing about a trade secret is it can last potentially forever. And again, it can protect an idea. Take, for example, the Coca-Cola formula. That's over 100 years old. Coca-Cola has never revealed how it's done. They don't have to. It's hard to figure it out, right? And they can keep that secret for forever as long as nobody reverse engineers it. Now let's compare trade secrets to patents, because that's often a choice that a startup will have to make. Do I protect my, let's say I have an invention or an idea, should I protect that with a trade secret or a patent? Well, one nice thing about a trade secret, again, it lasts potentially forever if you keep protecting it, whereas a patent only lasts 20 years. A trade secret has no disclosure requirement. In fact, that's the whole idea, is you don't disclose it. You keep it secret, again, kind of like the Coke formula. Whereas a patent, you have to disclose it. You have to tell people exactly how to do what you're patenting. So in 20 years, anybody can do it once your patent expires. And for a trade secret, it really only makes sense for something that's hard to reverse engineer. Again, the Coca-Cola formula is a good idea. If you protect something with a trade secret, when if I look at it, it's sort of obvious how it works once I see it and I can go reverse engineer it, a trade secret isn't a good approach at that point. It's probably better to patent it. So once it gets revealed, it doesn't matter if somebody can see it and see how it works and reverse engineer it. You have it protected via your patent. You can still exclude them from doing it, even though, yeah, you've obviously disclosed, you have to disclose how it can be done. So if something's really non-obvious and hard to reverse engineer, maybe you could think about a trade secret. Of course, the other thing about a trade secret is it can be a bit less expensive. You don't have to go through the whole patent application process and so forth. So that's a summary of the various rights for intellectual property: copyrights, trademarks, trade dress, and so forth. Again, these are all very good for an entrepreneur to understand and to review with an intellectual property attorney to make sure you take the right steps to protect the intellectual property for your startup. And that's a wrap for our overview of intellectual property.